Our difficulty is that we still don't have your written submissions. What is the situation?
Honorable Deputy Chief Justice, I beg leave.
Your mic on, please.
I beg leave to hand in a copy. It's a very brief submission. If permitted, I beg leave to hand.
Mr. Manyak, I must express our displeasure at the manner in which your client has treated this court. We bent over backwards to admit the BLA. It was close to midnight yesterday when we decided to admit it, despite Mr. Mketsu's startling statement in his affidavit that whilst they got to know about the respondent's position, they lost the whole weekend because seemingly they don't work over weekend while we slave away. You were late this morning. You yourself were late when you came to meet me in chambers. And now this. What is the explanation for this late submission? When are we supposed to read them now?
My lady, the reason for lateness on my part, I emailed the practice note to my attorneys who has been facilitating this matter. I came into this matter very late. My client requested me to come and present their matters. And realizing that they do not have anybody to do so, I accepted the matter to come and have their view to assist the court in that respect. And I did whatever I could in the circumstances I could. And around 2 o'clock, I sent the practice note to which it has the submissions in it. I thought the attorneys would facilitate. Then I went to go and have a small rest. From my end, I was here before 9:30. Maybe I ought to have been here at 9. In that respect, I will apologize if that was required.
All right, we'll grudgingly accept those submissions, but you'll have to help us through them because we have not seen them.
Indeed.
Just take us through them.
Before I hand the copy.
Sorry, no, hand them in.
I beg you to
Hand them in. But it's very grudgingly. You must know that.
My lady, this court is in a difficult situation. The difficulty is the rights of people who are not here. The difficulty is created by people who've got the rights under Section 19(2) of the Constitution. The right to have regular elections, and should this matter not be properly handled, those rights may be violated. But still, this court is trusted to see to it that the Constitution, as good as it is, as beautiful as it is, assists or is a vehicle for justice. My clients come in at a stage where my client realizes that the court might be in a difficult situation, pressurized by the fact that the election should proceed. And to provide the solutions, justice may sitting somewhere else feels that dismissing maybe the application or whatever will assist it to go on. But justice, where will justice be in that circumstances? That will be the argument that which we presented, to say that in the attitude or the approach this court takes, it should be to dispense justice. Now, one looks at the applications under which I come in and address the court. The application is an interlocutory application in nature. It is an application under Section 167(7), as I would submit, of the Constitution. It is, why is it that? I would be saying if one takes regard that The application for recusal is a means to promote the rights that are protected or conferred by Section 34 of the Constitution, fairness of the process. If one looks at Section 34, interpreted properly, maybe it's important that I refer to it briefly. Section 34 of the Constitution reads, everyone has a right to have any dispute that can be resolved by application of law decided in a fair public hearing. One would underline the fair, before a court, where appropriate, another independent, emphasis on that independent and impartial. The court is exposed to a situation, is looked at by the whole nation to check these three elements: fairness, independence, and impartial in handling all these applications. My clients have the view that they've been sitting back, things happening, and somewhere that they would have helped the court if they procured counsel like myself or somebody else to come and assist the court. Maybe would not be where we are. Late as it is, they say, let's go in and go and try to assist the court. The assisting the court, one may say, where is the problem? Why did the problem arise? Ours is to say, when you set the date of election and you disqualify other people, you are creating this tension. It starts there. If our system had a situation where we could compel or pressurize people to settle and have this matter off so that the court doesn't get tainted by being put under pressure. Because the court at the moment is under pressure to see to it the Constitution is protected, that they do what binds them in terms of Section 8.1 of the Constitution, which says this court is bound to give where we're dealing with constitutional right. Section 34 is a constitutional right. Now you take it with the application in particular, application for recusal. It's a constitutional right, equally. If you want to interpret that, whether it will be fair, whether they sit, they don't sit, my argument, it's a constitutional question. It's not an ordinary interlocutory application. It's a on its own is a constitutional question. Now, one may say, now where do we find the remedy on these things? If the court may feel that if, taking regard that we left with 2 weeks, I think, 2.5 few days before the elections, what best can be done? The case of my client is, there's a remedy. The court should look, we submit, that Section 75, one should be given effect. We should look at those that, how judges, other judges be appointed, acting judges, to come and look at this, where there will be no issues whatsoever. Somebody may say, where is fairness? My submission is, we having, say a young man like me is a president, and after 10 years I'm still as this young. People still like what I'm performing. But we have seen our president, after they've served 10 years, they sit back. Irrespective of whether they can objectively still perform, whether they simply for objectivity. South Africa believes, this constitution, that there are so many other men who are competent who can do the same thing I'm doing. Equally, there are so many judges, other than the honorable justices that sits here, who can do the same work. That's why after 10 years or acting as a Chief Justice, we ask you to go off. Even if you're doing well, you can still objectively deliver good. We're not saying we can't deliver good, but the trust in the pool, use of the pool, so that democracy is protected. The attitude that which my clients come in is to say, court, they say a valve. Look a little bit back at valve created by Section 175 of the Constitution. If we can use that, it can ease our situation. The quagmire is you try to use Section 175. The Minister of Justice is not here. The judge is not here. The President of the country is not here, which are central to the appointment of acting judges. Now, if one tries to give them opportunity to come and speak with a view of rule of law, one would find that the 2 weeks that we should got will end up against the wall. Our submission would be, if, let's say, it would be less, or in the interest of justice, if an order is made that the President appoint acting judges to come and just look at this matter. It's a thin matter. I think they will handle it in a day or so. If they do that, then the President and or the Minister of Justice is ordered to say he's given a right to reconsideration. A remedy could be created that within so many days, 5 days, do so, if you consider being aggrieved because we did not hear you. Approach this court, this matter under reconsideration, so that we can come and hear them. That the way, it's one person who would be prejudiced. Unlike where you're finding that my organization is an organization of lawyers. They are of the view that I've listened to argument that has been changed and submission that has been shown. They reflect lawyers' perspective. So it means it's not only lay person. Other people who are not sitting here, one day they will be sitting up here, they are feeling this is the precedent that have been made. If, let's say, care is not taken, they may undermine the Constitution. Let us not be too forceful and whatever pride or whatever one may call that to say the power is on our hand. Try to balance the scale in such that people will see that justice not only done, but it is seen to be done. Section 165(2) of the Constitution emphasizes impartiality. Section 19(2), it is about elections, which are also fundamental rights that which we should also protect, even if those people are not speaking, who are not part of this. Indirectly, they are party, the whole nation is party to this process. The help comes from Section 39 of the Constitution. Section 39 of the Constitution requires of me, particularly one, that when I stand here, I should come up with international law helping the court. I do not have any at this stage because of the circumstances I was roped in. But if one looks at Section 39(2), it says, in interpreting any statute, including the Constitution, the court should promote the purport, the spirit, and the object of the Constitution.
Your point?
As a court basis. We submit, and my client submit that the court should see to it that the interest of justice tends to indicate in the utilization of Section 125. That's my address.
Thank you. If I understand you well, Mr. Makano, you are saying that the judges, the listed judges, I'm this side. I'm here. Thank you.
Thank you, Judge.
Thank you. The listed judges should recuse themselves, and you are coming up with a solution. You propose that acting judges should be appointed in terms of Section 175,
Yes.
1 of the Constitution. This court in 2012 had occasion to consider that issue in the matter of Premier Shopper versus Premier Western Cape. And at para 34 and 42, I'll read to you what it said. It said, however, any possible ambiguity is removed when we consider that a recusal from a particular case does not preclude constitutional judges from continuing to perform their duties of office. A recused judge remains required to perform the rest of her judicial duties. The action of recusal is the performance of a judicial duty. The effect of a recusal, therefore, cannot be considered to be an absence to allow the minister, in concurrence with the Chief Justice, to appoint an acting judge. And in para 42, that is at the end of the judgment, it said, accordingly, it is not possible to interpret absent in section 175(1) as covering a situation where constitutional court judges recuse themselves from hearing a specific matter. So I don't know whether you want to comment on that. It has been decided, which means that your proposed solution may not be possible if one has regard to this judgment.
In interpreting the issues or the difficulties that are before court, the court ought to be purposive and be directed more, number one, by section 39(2) of the Constitution. I haven't had an opportunity to look at that judgment, and I would submit it is.
Well, that's exactly what the court did. If you read the judgment at para 33, it actually talks about...
If I may ask, what year was it? 2012. All right. My submission is that one need not confine himself to language. The purpose of where we're going should drive the way this court want to take this matter to dispense justice and protect this constitutional ground, rights that which are alleged by parties. But if one looks at language and read at the language, we may find that the Constitution is a means to dispense injustice. I know that, but it's...
Any questions for Mr. Makhanya? Thank you, Mr. Makhanya.
As a court.
Thank you, Deputy Chief Justice. Mr. Siboto told me that he would like a second to clarify something that he believes is confusing. I'm not sure if I told him that I would ask. Mr. Siboto, who acts for the MK party, well, he acts for Mr. Kumalo of the MK party. So I promised him that the first thing I would do...
He indicated that he wants to interpose before you...
Before me, because he said this was going to be a second. Thank you, DCJ.
Thank you, Mr. Mkoto.
I'm indebted to DCJ. Thank you so much. Justices, thank you so much. I take the view that there perhaps was a misunderstanding on the position of my client. In the filing sheet, it says, affidavit by Jabulani Khumalo on behalf of Mkhondo Wesizwe. So the point is, he does not seek to intervene. He's simply deposing to an affidavit to a party that is already in front of this court. And he does not concern himself with the merits and the demerits of the case, save to just let this court know that Mkhondo Wesizwe, which is the president of, abides by the decision of the court. And I hope that is of assistance to the DCJ and the justices of the court.
We already covered that ground. I did put to you that the client says he abides the decision of this court anyway.
And he's not a party himself. He does not purport to be one.
Thank you, Mr. Anderson.
As a court, please.
Thank you.
Mr. Nkoto, you let Mr. Mpofu and I go on and on about your locus to address us on recusation.
Yes, no, we didn't want to interrupt the exchange.
Yeah,
but
well, you need to say nothing more. We have been finished with your notice to oppose, which was filed on 3 May already.
Yes, and it's at page 508 to 511.
Thank you, Mr. Director.
And if I can start then with the address, it's important simply to restate the test for recusal. It is set out in Masuku at paragraph 64. It is what I think Justice Gamble referred to as double reasonableness. So the first question is the reasonable litigant. The second question is the reasonable belief in the potential bias of the judges. Again, Justice Gamble was correct in pointing out that when we assess the reasonable litigant in the position of Mr. Zuma, we are talking about an ex-president with all of the attributes that were described. When we're talking about a reasonable litigant for MK, we are talking about a political party that did not exist at the time the issues that are said to constitute a ground for recusal arose. It is a party that was established in September 2023. The second principle is in Sarfu at paragraph 48, which is this court and the judges appointed to this court have a duty to sit. You have a duty to sit in every case that is in front of you. The third principle in Sakau versus INJ, between paragraphs 32 and 35, is that when you sit, we presume that you are impartial because you approach your job with intellectual forensic ability. Those are the three principles that will guide the way in which you approach the matter. When we then consider the pleaded case for recusal, it is at page 449 to 451, between paragraphs 10 and 13. There are really three grounds that are pleaded for recusal. The first is that the justices, the 6 justices, are tainted by bias because, and I quote, they unjustly, although legally competently, sent Mr. Zuma to jail. So it is considered in paragraph 11 that the decision to impose a custodial sentence on Mr. Zuma was legally competent. And what that means is that it was in law correct. The second paragraph is at paragraph 12, which is at page 450, that because you are bound to seek to interpret your own previous decision, you are also tainted by bias. And the third reason is the Justice Pillay reason, which is at paragraph 13, page 451, which is you have to follow the example of Justice Pillay. Now, if we examine each of them, the first one, tainted by bias because although legally competently, now legal competence could mean you were correct, or legal competence could mean you acted within the scope of your authority. Either way, the correct position here is that that is your job. You have to sometimes find people guilty of contempt and then sometimes impose a punitive sentence. That is what this court is expected to do. And it cannot be a basis for recusal, even if the litigant who is on the receiving end believes that it is unjust. The mere fact that they believe it is unjust does not make the decision unjust in the eyes of the law. It is a subjective assessment that it is unjust because he is on the receiving end of it. Many clients who lose cases before this court believe that the court has done so unjustly, but the court cannot be directed and dictated upon by their subjective beliefs. There is a case that is of some relevance but it is an English law authority which my learned junior found. It's called JSC Bank versus Ablayazov. It's reported in 2012, EWCA, I think it's a Court of Appeal, page 1551. And what it says that the mere fact that a judge earlier in the same previous case had commented adversely on a party or witness or found the evidence of a party or witness to be unreliable would not, without more, constitute a sustainable objection. And it's directly on point because it was a case where a judge had sent a person to prison for contempt of court, and that person in a subsequent case said that judge must recuse themselves, and they said that's not a basis for recusal. But we don't need to go to England, because S versus Basson, a judgment of the Constitutional Court, says in the course of a criminal trial, there are many adverse rulings that are given against a particular accused. At the end of the trial, that is not a basis to say there should be a recusal. And Basson is at paragraph 42. So that takes care of the first reason. The fact that you are bound to interpret your own previous decision, our view is similar to Justice Biltridge's. We don't see this case as an interpretation of the contempt finding. We see this case as an interpretation squarely of section 47(1)(e). But even if it were, it would not be a basis for recusal, because every time a judge approaches a new case, they are informed by precedent. In fact, you, as the justices of the Constitutional Court, are the best placed group of people to interpret your own judgments. And then we go finally to the Justice Pillay example. It is not relevant to what you have to do, because you don't have to follow the subjective decisions of Justice Pillay. It is not binding on you. You are required to apply the law on recusal, which you are familiar with because you decided Sarfu, you decided Sakau, and most recently you decided Masuku. So in summary, there is no basis for the recusal. You should dismiss it. Thank you, Deputy Chief Justice.
Thank you, Mr. Ngoto. Any questions for him, colleagues? No.
Thank you, ma'am.
Thank you. A reply, Mr.
Yes, thank you, Deputy Chief Justice. Well, there's nothing much to reply to.
Let's just give them a moment to set the time. It's on.
I thought it was giving me 1 second. Thank you. Thank you very much, Deputy Chief Justice. There's really not much to respond to because the address by Mr. Nkaitobi is really misses the point even more than what we thought earlier. Well, in his submissions, he said there was one ground for the recusal application. Now he says there are 3. So we'll take the second answer, the one he gives now, and deal with those 3. When we said unjustly, although legally competently, we did not mean what Mr. Nkaitobi says we meant, that the judgment was correct. I was at pains to point out, and this court knows very well, that Mr. Zuma in particular challenged that decision until there was no further room to challenge it. And the fact that it's, when we say that it's legally competent, we meant that it's final, that we accept as a matter of law, not that it's correct in that sense, in legally competently. But the important part is the first part where the litigants say it was unjustly so. The second point about the MK party did not exist at the time of the alleged infraction or bias is just a non-point, because it doesn't matter if somebody, if a judge pronounces on something 100 years ago, before I was even born. It cannot stop me from saying that there is a view, a predisposal to a particular view by that particular church. So it's not time bound. Similarly, if the litigant was not yet formed at a particular time, and it goes back, maybe kill two birds with one stone, it goes back to the Pillay J point. Despite the fact that I've already said, remember when Pillay J recused herself, the only party before her was the MK party, right? So it did not deter her, the fact that the MK party did not exist before that particular date. She still felt, as she correctly did, that to the extent that the matter also involves the candidacy of Mr. Zuma, and to the extent that that challenge to the candidacy was based on the judgment that she gave, her conscience would not allow her to sit in that matter. That's all. So it's not about the existence or non-existence. Then the other point about losing cases, I mean, I don't know if I really have to respond to that. Mr. Zuma lost the case of so-called Zuma 1 here, and lost the case of the rescission. He's not invoking those. If it was just about losing cases, then he should be saying, well, this judge has made me to lose Zuma 1 and Zuma 3 and so on. He's not saying that. He's deliberately honing in on the contempt of court judgment for the reasons that I was debating with Justice Matopo as to why, for example, Justice Matopo is not one of the listed judges. So that's really not a point that is worth any response. As versus Basson, there are two things. Mr. Ngatobi says that a judge cannot without more, simply because they have made rulings in the course of a criminal trial, recuse himself. Obviously, that is true. And the two reasons is that without more is exactly what is missing here. We have said the whole morning what is more and peculiar about this particular case. But also, Mr. Ngatobi's own words are contradicting him, because he says, as Basson was talking about something that would have happened in the course of a trial. That's exactly the point we're making here. That the trial, and the point I was making too with Justice Chief, the trial is, because of Section 35, has inbuilt protections to make sure that any unfairness or whatever could have been overlooked will be corrected along the way. As Justice Machid says, judges make mistakes, and those mistakes might or might not involve having deep-seated subjective views about this or the other issue. But the system has got a way of dealing with that. Here we're dealing with a different situation where there is no further court. It's not any trial. That's why we don't have trials in this court. A trial, by definition, means that you have another opportunity to correct the issues. I think there's one more issue.
You are way past your 5 minutes, Mr. Goff. I thought you were going to finish the point we were making when the bell went off.
I'm happy to do that, Chief Justice. I mean, there's nothing really much to...
Thank you. Any questions, colleagues? No. All right, thank you, Mr. Mpofu.
Thank you very much, Chief.
The court will take time to consider your submissions. We can't say exactly how long that will take, but it should not be all that long, so please don't go far.
Thank you.
You will be called once you are ready to come and give our ruling.
Thank you, Chief.
We need this for the future.
Is there a future?
Rather do it yourself.
At least the people have more time for that.
Yes. And if they don't, you'll take me to that.